At our very first symposium here, we had Christopher Hart, who is the chair of the National Transportation Safety Board, and he was talking about the extent to which systems versus individuals create problems. And one of the questions that he asked was, how many people have to trip over a step before you stop saying everybody's clumsy and you go and fix the step? And Brady versus Maryland, I think, presents a similar challenge. There is no question that there are intentional violations of Brady and intentional situations that are intentional for prosecutors. But the fact of the matter is, when you have a rule that started in 1963 and in 2017 you're not seeing any reduction in the number of violations of that rule, I think one of the reasonable questions to ask is, how can we change the rule? So two things are probably needed: rule changes and incentive changes. And to talk about that, our fellow Brian Murray has assembled a really terrific panel of folks that I will let him introduce, and we'll go from there. Thanks, guys.
Thank you, John. So as John mentioned, it's been approximately 55 years since the Brady standard was announced by the Supreme Court. And that, for anyone who doesn't know the precise contours of that rule essentially obligates prosecutors to disclose favorable evidence that's material to the guilt or punishment of the accused individual. And failing to do so is, in fact, a constitutional violation, although the remedies tend to hinge on things like absolute immunity or the ability to show prejudice in certain situations. But policymakers, attorneys, judges, prosecutors, mostly everyone in the system considers the rule crucial to pursuing accurate and fair convictions. But we still hear stories of tragedy and despair in the system due to Brady violations. As we just heard with the previous panel, defense counsel is probably, in most jurisdictions, if not in all jurisdictions, ill-equipped to fill the voids or the gaps that are created by Brady itself. In some situations, there are instances of blatant prosecutorial misconduct with respect to withholding of evidence. But in the vast majority of situations, well-meaning prosecutors run up against the forces and pressures and constraints of other individuals in an under-resourced system. And what ends up happening is the spirit of Brady, which is disclosure with an eye towards accuracy, runs up against maybe the public appetite for putting the bad guys away, right, or processing the cases that are in the system. And when the ethical commands to do justice or act as a minister of justice are less than clear, what we ends up happening is we have a system that might incentivize behavior that we would otherwise not really prefer to have. So today I'd like to explore a series of questions ranging from, when that complex set of circumstances exists, what should we realistically expect our prosecutors to do? Should disclosure and potential wrongdoing be subject to oversight, and if so, by whom? What internal procedures in offices actually work to limit Brady violations? What's the role of defense counsel and the adversarial system in general when trying to limit the number of Brady violations? Are courts and our judges part of the problem or part of the solution? Are laws like the Michael Morton law in Texas the best solution, or do they also lead to certain unintended consequences, and how are they implemented? Those are just some of the questions I hope to explore today, in addition to concepts of immunity doctrine. It's important to remember, and I think the Quattrone Center does a very nice job of messaging this, that the system we work in and study is populated by well-intentioned actors for the most part. people who in good faith are trying to do their best. But the rules and constraints that inform decision-making by prosecutors, judges, defense attorneys, and to some extent defendants, of course will affect their behavior. It's important to think about the types of incentives that those rules in fact create and foster. And how something like the doctrine of absolute immunity, first announced in Imbler by our court, the Supreme Court, which insulates prosecutors from liability in certain instances, what those rules actually foster. So today I'd like to go through some of the pros and cons of the Brady rule, whether it's workable or not. I'd also like to talk about the administration of the rule on the front lines, and then if we can agree on certain things there, what are the best avenues for reform? So we have a distinguished panel of guests here today, and I'd like to introduce each of them, and then I'll start asking the questions. Professor Bruce Green is the Lewis Stein Chair of Law and the Director of the Stein Center for Law and Ethics at Fordham Law School. He teaches and writes primarily in the areas of legal ethics and criminal law, focusing on the responsibilities of prosecutors and prosecutorial accountability. He also serves in various bar association positions, including as a member and past chair of the New York State Bars Association's Committee on Professional Ethics. Previously, Professor Green was a federal prosecutor in the Southern District of New York and a law clerk to Justice Thurgood Marshall and Circuit Judge James Oakes. His writing has been published in the Yale Law Journal, Notre Dame Law Review, Georgetown Journal of Legal Ethics, and numerous other law journals. Professor Alafair Burke is professor of law at Hofstra Law School, teaches criminal law and criminal procedure, and researches the intersection of law and procedure and policing and prosecutorial policies, including with respect to prosecutorial decision-making in a variety of pretrial and trial contexts. Her scholarship has been published in the Yale Law Journal, Michigan Law Review, and William & Mary Law Review, as well as other journals. Before entering academia, Professor Burke served as a deputy district attorney in Portland, Oregon. She's also the author of 11 best-selling crime novels. Bill Wirskye is the first assistant in the Collins County District Attorney's Office, serving under District Attorney Greg Willis. Mr. Wirskye has extensive trial experience, having previously been both a criminal defense lawyer and chief felony prosecutor in the Dallas County District Attorney's Office. He is a member of the Texas Prosecutor Society and serves on the Texas District and County Attorneys Association Training Committee. His cases have been featured on Dateline, 48 Hours, and the Investigation Discovery Network. Finally, Keir Bradford-Grey became the chief defender for the Defender Association of Philadelphia in the summer of 2015. Prior to Ms. Gray's appointment, she was chief defender for Montgomery County of Pennsylvania, an assistant federal defender at the Delaware Federal Defender's Office, and between 1999 and 2000, she was an assistant public defender in Philadelphia. She's pioneered the use of DNA, linguistics, and handwriting expertise in constructing effective criminal defenses and earned a reputation for high ethical standards. She has implemented a number of groundbreaking reforms focused on client-centered representation. So to start it off, I'm going to ask each of you this question, and each of you can take a couple minutes to respond. 55 years later, was Brady the right rule? And is it workable? Go first.
I have a little bit of a unique perspective. I think I came up in the Dallas County DA's office at a time where we had a lot of the wrongful convictions that Mike Ware talked about earlier that were righted. Those wrongs were righted under Craig Watkins. I can tell you I worked with a lot of the detectives and the prosecutors that prosecuted those cases and investigated those cases. We thought we were doing a good job. We thought we were rigorously and scrupulously applying Brady. We used to have long, angst-filled meetings to determine prospectively what was material, what wasn't, what should be turned over. And then the exoneration revolution hit us smack in the face. So from my personal perspective, we thought we were vigorously complying as prosecutors with Brady, and the proof is out there that we weren't. We weren't doing enough to prevent these wrongful convictions. So from my perspective, I think Brady is just too complicated. It's a cognitive trap for prosecutors to make this materiality determination prospectively looking forward. And it's just not something that we should engage in. And you mentioned earlier, Brian, in your remarks, we do have the Michael Morton Act, which we'll talk about in a while. But the Michael Morton Act in Texas has at least simplified a lot of the concepts surrounding Brady, and for that reason, I think it's better. But back to your question, I think it's flawed in many deep respects.
First agree.
So I would say, although the answer is almost certainly no, it's not the right rule. Whether or not it's the right rule and why not depends on what you mean by the question. And so I haven't reread Brady in a while, but Brady was really a case not meant to be setting the discovery standard for prosecutors. That's done by rules of criminal procedure or court rules or other things. It was really a due process case. It was about when is withholding evidence, which in that case probably was evidence that would establish the actual innocence of the defendant. When does it violate due process? So that was a case, as I recall, that probably never should have been prosecuted. And the issue was it an unfair conviction? Was it an unreliable conviction? And part of what made it unreliable was the fact that the person was innocent, and evidence withheld by the prosecutor in the unique possession of the prosecutor would have essentially established that. But over time, it became an unworkable rule because it the cases tried to make it do more and tried to make it basically about discovery. And so if you're talking about what does the defense need to have in order to test the prosecution's proof, in order to enable clients to make informed decisions whether to plead guilty or not, in order to make trials reliable, Brady wasn't meant to do that. And if it's measured against those standards, it's a terrible rule, leaving aside the problems of implementation, because it's not enough. We have a standard in civil litigation which presupposes that the way to get the truth is to have each side be able to present the evidence most helpful to their side. And to the extent that evidence that might be helpful is within the possession of the opposing party, you pretty much get access to it. You don't get access to the other side's legal theories, but you get access to their witnesses, you get to depose them, you get access to their documents, their evidence. They have to answer questions about what their theory is, interrogatories, etc. And then in a trial with both sides presenting the best evidence and cross-examining the other side's evidence, we presuppose you get the truth. We don't have that system in criminal cases for reasons that have to do more with accidents of history than with logic, But Brady is not the cure-all for that. So let me just stop there, and I'm sure we'll all get to say a lot more.
I was going to say Brady was the right rule, but for a different problem altogether. And I guess I'll land in the same place as Bruce is in the early Brady cases. I suppose the court could have said, we have an adversarial trial system, each side gets a lawyer. If the jury says this guy was guilty, even if they didn't hear some of the evidence, too bad, so sad, we have nothing to do with this. So Brady was the right approach to find a way to correct wrongful convictions when there was actual evidence of innocence that the prosecutor was actually aware of, and chose not to disclose to the defense, let alone tell the jury, let alone dismiss the case, and instead sit there with a straight face and argue guilt when they were directly contradicted by evidence in their own file. So Brady was a perfectly good approach to correct that specific problem, but 55 years later, to continue to look at it futilely, in my opinion, to try to shape something like everyday discovery rules in everyday cases in a very busy criminal justice system where almost everything pleads out and doesn't go to trial, it would be like using the Sixth Amendment's speedy trial clause and the Supreme Court's multi-prong amorphous balancing test to try to decide when to set cases for calendar, right? There's a reason we have local rules. There's a reason why we set a 60-day clock or a 30-day clock, depending on what jurisdiction you're in, instead of looking to something so amorphous as Brady is, and I'm sure we'll talk about the many ways that it's amorphous. I assume we'll get to that later, right? Okay.
Thank you. So hard to come after the academics, but I'll do my best. I think Brady alone is never going to get us to achieve fair trials. However, Brady, if enforced, or if the court had provided some clarity on what the standards of Brady should be in terms of understanding when prosecutorial misconduct occurs, would be something that we can use as a remedy for when things don't happen. I believe in a system such as Philadelphia's, the Brady rule will never allow us to understand what types of information should be given or what types of information will be withheld. That has to be done locally by both, I guess, organizations who are more involved in this daily. So in terms of looking at something to guide us to, with respect to constitutional due process, I don't think it harms us in terms of having certain due process rights being stated. However, the court's minimalist approach to enforcing it is what really hurts and does not incentivize prosecutors to adhere to those due process requirements.
Great. So before we get into the interaction between the Brady rule and local rules and federal rules of criminal procedure, I think since everyone's kind of alluded to the ambiguities in the Brady rule itself, if you had to pick the biggest problem in the Brady rule itself, what is it? Is it just the ambiguity related to materiality, or is it something else?
May I? Oh.
Keir, you can go first.
I think it's the self-regulation. I mean, we are asking prosecutors to make determinations as to what is going to be helpful to defense, when most of the times they're biased as to what the information that they have in front of them reveals. So if you're asking a prosecutor to look at their case and say, I wonder if certain pieces of evidence will negate the guilt that I'm looking at that's obviously there in my, by the police report that I've been given, I think that's going to be hard to practically enforce and hard to ask a prosecutor to get into the mindset of a criminal defense lawyer or try to figure out where their defense may be going, or what can help them lead to other information that may shed some light on a favorable outcome. So the self-regulated, rule where prosecutors themselves are making these decisions, I think that is one of the major problems with the rule in Brady.
I guess I would say that it's not actually a rule, it's a standard. And so when you couple that with Keir's observation that prosecutors are supposed to apply it to themselves, if it were a very firm rule, like, do I have a witness saying contradictory things? Did a witness say X on one day and not X on the other day? That a prosecutor might be more able to implement than something that is not rule-based. So I guess I would say the fact that it's just a standard of is it material and is it exculpatory. I know we can go on and on about the problem with the materiality standard. It's almost like a harmless error standard. It assumes the case has already been tried. It's a retroactive standard, not a prospective standard. But even the part that requires prosecutors, Brady only touches on exculpatory evidence, not inculpatory evidence. It's not always going to be obvious to a prosecutor what's exculpatory. They don't know what the defense attorney knows. They don't know the defense's theory of the case. And cognitive biases could cause them to see something as inculpatory or ambiguous when in fact somebody else would see it as exculpatory. So even that part of it, I think, is a challenge for prosecutors to look at a case that hasn't been tried yet and try to figure out what that's going to look like after the fact.
So I do think that when the prosecutor sits down with a universe of information and documents and tries to figure out what is exculpatory and what of that is material, and to do it in a self-regulated way. All of that creates difficulty and ambiguity, and cognitive biases lead you to minimize the significance of this, the fact that you may never have been a defense attorney, the fact that you don't know this defense lawyer's theory. Lots of things would lead you to go astray. But to me, there's a starting question of what's in that box, maybe not literally, metaphorically, of information that the prosecutor has in the first place. And so I think, to me, one of the problems is if the theory of Brady is, as I understand it, directed at all the information in the government's possession, not just in the prosecutor's possession, one of the problems with it is what gets memorialized by police, what gets from the police to the prosecutor, what even that the prosecutor herself may have generated gets memorialized. And so to me, I think as big a problem as the ambiguity of the standard is the lack of understanding about how police practice and prosecutor practice is structured in order to memorialize the information from which prosecutors decide what to turn over.
And I agree with all those comments, and just to kind of double down on the professor's remarks, as a prosecutor, it's very hard for me to get all the information. My police officers are reading Brady too, and I'm not the only person having to prospectively apply the cognitive trap of Brady's materiality. If I've got police officers doing it too, I don't know necessarily what I've missed. So just to follow up on the professor's remarks, I think that's a huge problem in the day-to-day operations of Brady.
So following up on that last identified problem, Bill, maybe you're in the best position to speak about this right now since you're still practicing as a prosecutor. What does your office do to ensure that the material that it has in its possession when it's making the determination is what it's supposed to have? Is there a conscious effort on the part of the prosecutor's office, and how so, to oversee investigatory agencies so information doesn't get lost in the fall through the gaps?
Not to jump too far ahead, we do have Michael Morton in Texas, which basically mandates an open file, which gives us, when we go out and train, when we work with our police agencies, gives us the leverage to say everything means everything. We need everything. We're really relying a lot on checklist theory, giving checklists to our police, checklists to our prosecutors to make sure we don't miss anything. And we've just been very aggressive in trying to ensure that, because the team is the team, that we know what our police teammates know, and trying to get all that information in.
Here in Philadelphia, where you don't have open file discovery, what has your experience been with the potential gaps that might be created in the construction of information between, or the passing of information between investigatory agencies and prosecutors themselves?
Well, I think the gap is that we don't know what they have. I mean, that's really the reality of it. And oftentimes, we have to say that defense attorneys are not always understanding of what types of information are available to them as well. We don't know what types of forms that all of the police agencies or law enforcement agencies keep. We don't know these things until we have a case that has been brought on review through a lengthy process, and then we start piecing things together and now looking at it from the back end. But when you're looking at a system that has an overburdened, caseload, trying to come up with a list of information that will be pertinent to every case, because every case is unique, is really tough. And so I think the issue is that, if there's an open file or becomes an open file in Philadelphia, we'd be stuck with what was in the district attorney's file, which may not always include all of the information gathered at the law enforcement level. So I don't know if that answers your question, but I just would not know until that was available to us.
And not to put you on the spot, but we're gonna come back down from you for this one. but is it your experience, or do you think that prosecutors, when weighing the decision about what to disclose and what not to disclose, are thinking about, will this alter the verdict itself, or will this create a more confident result in the outcome of the case? Because there's a divergence in the progeny of after Brady, and those are two different things. What do you think is on the mind of the prosecutors? And then, since the three remaining panelists were prosecutors themselves, what is their experience?
So personally, I believe the adversarial nature of the process takes control. I really do. I think that prosecutors start to believe in their case, and they believe that their obligations to look at whether or not the information is material to the outcome. And, you know, if you think that you have a strong, solid case with independent evidence, then you're going to make those decisions. But I don't think that that was originally, the original intent of the Brady rule is to say whether or not this would change the whole outcome. Your obligations and what they look at in terms of a violation are two different things. Prosecutors' obligations are to turn over anything that they may have in their purview that may lend itself, even if it's not admissible, that may lend itself to other evidence that's favorable. And I don't think that that determination goes into a prosecutor's head when they're getting a case that they believe in, and they're saying there's no way, even if I have a cop that was found 5 years ago, found to have some ethical issues. Well, he's cleared that, he's still on the force, and now in this case, everything was done by the book. So I think that there's certain information that they're not really weighing in terms of what I would need to go about doing my investigation and how that would lead me to other areas.
Bennet Gershman, he's at Pace, right?
Yes.
A professor at Pace has a list of statements that might be made in a domestic violence case where the victim calls the prosecutor while the case is pending and says, I exaggerated, or I hit him first, or the police got something wrong. And he read it to a list of currently practicing prosecutors. He gave them the list and asked them, would you disclose this, statement, all these statements. Basically, it was 50-50. There was no consistency. Nobody agreed on what they would turn over and what they shouldn't. It was his view it should all be turned over, of course. And that doesn't surprise me at all. I think, Keir, I agree with you that the standard should be, is this something that would be helpful to a defense attorney? If I were the defense attorney, would I want this? Would I think it would be something that would help me help me meet my obligations of effective assistance of counsel? If that were the standard, I think prosecutors would have an easier time implementing it. But if you take the Supreme Court literally on its face, it only applies to material exculpatory evidence. And that materiality requirement, although it doesn't have to be a smoking gun of innocence, if you take the court literally, I guess these days we're not supposed to take government figures literally anymore, but I still do. It says, is this evidence that could be seen as putting the verdict in a different light? Does it shake your faith in the conviction? That hasn't happened yet. And when I go around and I talk to prosecutors, and I don't call it Brady evidence, if I say to them, if you found something in the file that made you think that if you got a conviction, you should have doubt about it, what would you do? And the answer isn't turn it over. There's a bunch of prosecutors in this room. If you found something in your file that shook your faith in the way you saw the case, what would you do? You'd probably dismiss it, right? So taken literally, a lot of very ethical prosecutors might say there's really no such thing as Brady evidence. If I had Brady evidence, I wouldn't be prosecuting the case. So instead, Brady evidence becomes kind of shorthand for, is this the kind of thing, if I don't turn it over and it comes out later, like how's that gonna look? I think it's almost like this gut check. And I know that where I practiced in Portland, Mike Shrunk, who some of you may know, who was a prosecutor there, the DA there for 30 years, he always told us, if you stop to think about it, it's because you don't want to turn it over. And the reason why you don't want to turn it over is you think the defense attorney is going to turn your life into a nightmare for a couple of weeks. And so you should turn it over. which is a very under-theorized way of looking at it. It's not something, you could write a rule around, but it was always the rule of thumb. If you're thinking about it, you should probably turn it over.
So I think when it comes to Brady, there's a lot we don't know. If you were a social scientist and you actually cared about data and things, you would have to say that we just don't know so much. We don't know how often prosecutors fail to turn over things which we think ought to be turned over. Nobody audits prosecutors' files to see, who left stuff behind. And of course, that says nothing about what the prosecutor never got a hold of in the first place. We don't really know what thought processes prosecutors go through, and there are so many of them and so many offices around the country, and so which prosecutors are we talking about? When I talk to prosecutors, they tend to generalize based on one prosecutor, that's themselves. And that's always a really honorable, ethical prosecutor who would never willfully withhold something. And so one of the things we don't really know much about is the mindset of prosecutors. And I don't think it's uniform. I think it's very different. I think different offices have different cultures, but even within a given office, different prosecutors are very different, and they could be different depending upon whether they're drug prosecutors or white-collar prosecutors or just whoever that individual happens to be. But I would say this. Every prosecutor I know, if they were on this panel, would say, when in doubt, we turn stuff over. If you have to ask the question, as Mike Shrunk says, then unless you're talking about protecting an informant's identity or something really important on the other side, and in that case, you might think harder about it, or you might go to the court and ask for a ruling. But otherwise, in close cases, we always turn stuff over. That is what you always say publicly. But I would say, based on my experience talking to people privately, there's kind of two different standards that some prosecutors have. And so, yes, Brady is kind of about the legal standard. Would this be super relevant? Might it be really important? But then they look at stuff and they say, I don't think it meets a legal standard, but tactically, this could be really useful to the defense. They may make a lot of hay out of it, a lot of smoke and mirrors or whatever. And so I don't want to turn it over because I don't think it's really legally important. I just think it's going to make a difference. Now, that cannot be the standard, right? I mean, if it's going to make a difference, that tells you got to turn it over. But I think that is not an uncommon mindset, and that's part of the problem that we have here.
And Brian, just to close the loop on your original question, I'm not sure all those old discussions we used to have about what's material or not, we actually had time or even gave it the thought to think of it in that terms. We just, is it material? And we came back around to Alafair's bosses. If you have to stop and think, if you have to ask, if we have to have this discussion, it's Brady, turn it over.
Can I just ask, when you say we, do you mean I? Or do you really know that all the people around you had the same approach in the privacy of their cases?
I can't vouch for that. Usually these are group discussions, so there's that aspect of it. What people do in their own office and their own shredder, no.
So a common thread here is this idea of tunnel vision kind of creeping in, right? And possibly making an already ambiguous standard even more difficult to administer on a day-to-day basis. So what's the solution to that, though? Is it more training in cognitive bias? Is that enough? How do we change office cultures that might be problematic? Bill, you having the open file discovery in Texas, have seen where you were and can talk about now where you are. But what was it like when it first changed? Did you run into, I'm throwing a bunch of questions at you, but did you run into implementation difficulties? Was there an office culture that was tough to fight against?
We've had the Michael Morton Act in Texas since January of 2014. Basically, it has a couple of different aspects. It is a mandated open file policy. All the material in possession of law enforcement and the prosecutor's office, with certain limited exceptions, needs to be turned over. It also talks about Brady and codifies and extends Brady. It's now a statutory mandate to turn over any exculpatory evidence regardless of materiality. And actually, I just said evidence. It's not even, doesn't use the word evidence. It used the word information and material. And I absolutely love it as a prosecutor. All these discussions, all these things that we used to wrestle with, we simply don't have to anymore. You know, it's a much more workable standard for the working line prosecutor to implement. Does it cause a secondary set of concerns and unintended consequences? Sure. Now we talk in terms of completeness. We're over at the police station a lot, browbeating our detectives. Do we have everything? Now we have body cams coming on all over the country, especially in Texas. When you have an open file policy like we do in Texas and you have the rise of digital media evidence, it creates huge unintended consequences and unfunded mandates. And we're working through that as a system, but overall I think it's a really great thing. I'm not sure, and I'm a big believer in cognitive bias training, and we do a lot of that in Texas prosecutors, but I'm not sure that alone would have been enough to solve the problems. And the exoneration revolution that's the epicenter in Dallas really shook a lot of people up in North Texas, across Texas, including myself. And, you know, I'm not sure any sort of training or anything self-regulating would have been enough. I believe it called for a drastic measure, which is the Michael Morton Act.
Bill, can I just ask a question? Bill, how does the Texas law deal at all with impeachment? How deeply does it go? Like, you know, prior complaints against police officers, for example.
Yeah, we're required to turn over impeachment evidence. In fact, to the extent of some of the ramifications of having the Michael Morton Act, all the offices in Texas now are providing, they're typically called Brady list. We call ours a disclosure list. We are kind of data mining the police misconduct files and giving appropriate notifications. Right now in Texas, currently going on with some help of the good folks at the Quattrone Center, we are going into the forensic world. All the mistakes that happen in the lab, the misconduct, the error, we are actually mining that to see if there's information there to be turned over, and that's all a work in progress. But I don't think any of that would have happened without kind of the legislative
that'll just
change.
get turned over in every case?
I'm sorry?
The idea is that will get turned over in every case?
Yes. So, I mean, I'm pretty proud of what we're doing in Texas. I know we have some Texas lawyers in the room, but I think we're doing a pretty good job. Obviously, we're not perfect and there's a long way to go, but I'm pretty proud of what we're doing.
So change through the legislatures, as we know, is not the easiest thing to accomplish. So I guess to follow up on my original question, if we're operating in a jurisdiction where there's no hope of the legislature passing an open file law for whatever reason, right? Just because it's stuck in committee or hasn't even been introduced yet, or there's a big lobby against it, whatever the reason. If that's the case, and maybe I'll direct this question, I'll start with you, Keir. What can fill the void then, right? To make sure that this evidence doesn't, just get bottled up and not disclosed? I mean, is it just local rules? Is there a specific role for defense attorneys to, think creatively about how to get discovery in other ways?
Oh, absolutely. I mean, we do that now. We have to think about how we're going to get our information, because you have to remember, some of the discovery rules don't even kick in until a certain time frame has passed once a person is arrested. And I know I was reminded a lot when I was at my former post that we're not required to give you discovery until 30 days after arraignment. That someone can be in the system for about 3 months, at the time of the formal arraignment. A lot of information is lost. So what we did is that we started to go to the communities and create what we call these criminal justice hubs called participatory defense. And it was designed to help our investigators get the most pertinent information at the time frame more close to the arrest. We know that in the age of digital the digital age, information is stored for a certain period of time, and that information can be very, very pertinent. We don't necessarily get from police officers if an offense occurred in a certain area, is there a camera in that area? Are there stores with cameras? So this information is not just given to us by the Commonwealth. We have to actually search for that. And that gives us an understanding of what type of information we should be asking for going forward. But that's also after we've already experienced the failures on the cases. So in Montgomery County, and I was so proud of this, we used an initiative that was going on in California called Participatory Defense. And so we worked with communities to understand the system from the original arrest to the preliminary arraignment, all the way up to the formal arraignment, and how to gather information for us. So that would lead us to make requests on the district attorney's office. And what we were getting were people that were willing to take pictures of certain scenes that we weren't getting in regular discovery. We were getting things that would give us, recordings or information about a store that had a camera. And this was so much more helpful because the community is our best untapped resource anyway. They know more about what's going on in that area than the police in most instances. And so I think that we found that creative approach really helpful to our discovery requests because it led us to ask for different information that we wouldn't originally have even thought of, but for that information coming to us early.
Following up on that, and I'll direct this at Professor Burke and Professor Green, how do courts help or inhibit compliance with Brady? You know, it's a common critique that courts are just too deferential to prosecutors. Is it your sense that that's the case in the federal and state, and you can talk about it in either the federal or the state system? And if so, what can be done about that?
Well, I would just say in the federal system, at least, which I know better, prosecutors, if there's a request for Brady material, prosecutors say, we know our Brady obligations, and the judges assume they do, and the last thing the judge wants to do is wade through the prosecutor's file to make Brady determinations, and so that's pretty much it. Now, there is a movement to try to get judges to issue what have been called Brady orders, I think, to explicitly order disclosure of Brady material and other material that the prosecutors already ethically and statutorily and constitutionally obligated to turn over. The theory being that in that case, if the prosecutor doesn't comply with the obligations, the court could hold the prosecutor in contempt, and that may be an added incentive to comply with your obligations. That may be helpful. I don't know. It doesn't seem like a very big step to me.
Yeah, there's really no neat way in the ordinary case for courts to get roped into the discovery process, right? So the more the stuff's routinized, the more effective it will be, right? Instead of using an ad hoc case-by-case system where individual prosecutors just sit down and decide what to turn over, whether it's done by statute or local rule or even an internal prosecutor's guideline, right? Prosecutors can choose to disclose whatever they want, right? So you can have an office policy of either open discovery or, something like the U.S. Attorney's Manual even implements Brady not just by saying turn over material exculpatory evidence, but actually outlining these are the things that we consider to be Brady, like inconsistent with witness statements, and sort of providing guidelines about how to. It's almost like a prophylactic, right? A way to reach Brady is by delineating these categories of information that are likely to be Brady without you sitting there trying to decide whether it is in this particular case or not. One way courts could be involved is rather than doing it on a case-by-case basis, though, is to try to lead a reform movement in their jurisdiction, right? To try to set norms within a jurisdiction, just like a prosecutor's office can. I mean, they wouldn't have the power, I suppose, to order it other than a Brady order. But courts can shape prosecutorial policies if they want to, right? If they think Brady violations are rampant, they can lean on people to say, get your shop in order, it seems like.
So some federal courts have local rules. The District of Massachusetts does, and I think some others do that, go beyond the statutes in Brady. And some judges, I think, have, their own judicial rule requiring what gets disclosed. In the Second Circuit, a judge tried to impose a rule requiring earlier disclosure than the law would require, and got shot down. But I think in other jurisdictions, the courts can do that.
What about the fact that a lot of courts, I hate the standard of putting the burden on the defendant to show that the evidence would have undermined the verdict, right? Because when you're looking at a record of, and it was a guilty verdict, it's hard to do that. What about reversing the burden of proof? Make prosecutors show that their error was harmless beyond a reasonable doubt, rather than saying, should the defendant show whether or not they would have won, the prosecutor should show why they kept this out and whether or not it was harmless error or an intentional decision beyond a reasonable doubt. Maybe that reversing the burden of proof may help them think about their obligation a little bit more and incentivize them to turn over more.
After the Ted Stevens prosecution, which was a disaster, the Alaskan Senator Murkowski proposed federal legislation that would have required both broader disclosure than Brady, because it would have required disclosure of favorable evidence without regard to materiality, and would have changed the standard to the harmless error standard. So the burden would have been on a prosecutor who withheld favorable evidence to show that it wouldn't have made a difference. Of course, the whole problem with that is if the prosecutor is going to withhold the evidence prior to trial, how are you going to get it after trial? It's sort of, the aberrational case most people assume, where the evidence then emerges after trial and you get to make your argument that it wasn't harmless error.
Professor Green, I want to come back to you just for another question with respect to some of your previous works. You write extensively about ethics. What is the role of the professional ethics here? Is it just a paper tiger? Can it be used to actually incentivize behavior? And if so, what needs to happen for that to be the case?
So there's two, I guess, points that I would make in response to your question. One is the ethics rules themselves can expand the standard of disclosure. And so Rule 3.8D of the ABA model rules, which most states have some equivalent rule to, requires disclosure essentially of favorable evidence without regard to materiality, or at least that's the way it's been interpreted by the ABA. And so if you're in a state that has 3.8D, you could make an argument that prosecutors should not make a materiality determination. They should just turn this stuff over. A number of state courts have considered this. Some have agreed with the ABA, the Washington, D.C., for example. Some have said, we don't care what the rule says, and the ABA says the rule says. It's coextensive with Brady, but that leaves probably 40-plus states that haven't weighed in. The other question is, do you use disciplinary enforcement as a way to incentivize prosecutors to comply with the obligations that they undeniably do have by, for example, disbarring, suspending, publicly reprimanding, privately reprimanding prosecutors who withhold stuff that they're supposed to turn over, and if so, when it's intentional, even when it's negligent. So for a long time, disciplinary authorities did not go after prosecutors, in part because they have lawyers who are committing felonies and stealing clients' money and doing other things that most of us would think are more serious, probably for a host of other reasons as well. To some degree, disciplinary authorities are now going after prosecutors when they think that there was a willful failure to disclose important evidence, and a couple prosecutors have been publicly sanctioned. I don't think that's the most efficient way to deal with the problem, but it is a part of the solution.
Bill, are there disciplinary components to the Michael Morton law in Texas?
We recently had a case within the last year in Texas. Traditionally, our rule had been kind of interpreted to be coextensive with Brady, but our Board of Disciplinary Appeals revised that, so there is now no materiality component to our disciplinary rules. So everything means everything for us when it comes to exculpatory evidence.
And are the conversations in the wake of the Michael Morton law, in terms of disclosure, mostly still about this is a legal mandate, or do you still have conversations about the ethical components as well?
It's really changed the nature of the conversation for us as prosecutors. We really just talk in terms of completeness. Do we have everything? Have we laid a good paper trail to show that we've given everything over to the other side? And we just don't get into disclosure at all. To the extent we talk about disclosure, it's these new avenues, going into police officer misconduct, going into the forensic lab. That's where we kind of look there to the new frontier of Brady, basically. But traditionally, the material you would amass to prosecute a traditional case, we just talk in terms of completeness and transparency.
So one disciplinary measure that was passed essentially in California was a statute that actually criminalizes intentional withholding of information by a prosecutor, makes it a felony. That's obviously not the norm in the other jurisdictions in the country. What are your thoughts, all of you, what are your thoughts on that approach to the problem of failing to disclose?
Well, to be honest, I think the stakes are so high in our system that when you prosecute someone and you're giving someone a lifetime record, that you should be as ethical as possible. So intentional withholdings, you know, I'm not a one to criminalize behavior a lot, but quite frankly, I think that there, you know, we need to recognize the fact that this shouldn't be something that's easy to do. We shouldn't hand out felonies and hand out convictions so easily and think that people are just going to be able to get over it and outlive those things. So I think that more stringent opportunities to make prosecutors really adhere to their pledge to fairness, right, during the process. They're supposed to be truth-seeking people looking for justice. And if they don't adhere to that, then I think that they're acting criminally in certain ways, because you have ruined a person's life because you intentionally did something. One of the things that I have a hard time with is this notion of exculpatory evidence. And I think, Professor Green, you said it best. What does exculpatory evidence mean to each person? And if you don't have, like Professor Burke said, a strong list of very delineated things, how does one know on an individual case what's exculpatory and what's not? That word exculpatory is so expansive, and so it can be interpreted in so many different ways. I don't know if you can put criminal liability where it's so unclear, but intentional withholding, when you know definitely this is something that I should turn over and you intentionally withheld it because you believe in the strength of your case otherwise, I think that is as egregious as it gets for people that are supposed to be seeking justice.
So to me, the law is largely symbolic because I think it's always been a crime of obstruction of justice for prosecutors or any other lawyers in the system to willfully withhold evidence that they had to turn over. But there are virtually no prosecutions. There was one federal prosecution of a federal prosecutor in Detroit in a terrorist case who ended up acquitted. But I don't see prosecutors prosecuting their brethren very often. And also, I don't actually think the main problem with Brady is willful violations. And so I think, this standard is just not broad enough, so even if people complied 100%, that wouldn't satisfy me. And also, I think that failures to disclose are for negligence or cognitive bias or misunderstanding or a million other reasons before they are for intentional non-disclosure. So maybe, having the crime will focus people's minds and make them more careful, but I don't think that's a big part of the solution.
Yeah, I think to make that too big a part of the solution, it can actually backfire because you're chasing what I think is the wrong problem. You're chasing, it's like a unicorn. You've got the poster child where you can actually prove beyond a reasonable doubt that someone recognize the exculpatory value, recognize that it was material, and then intentionally didn't disclose it, yeah, if you do whatever you want to them, that's fine. But the danger in making that the centerpiece of reform here is, I think it's prosecutors really hold the most power. They can fix this tomorrow with open file policies. They could fix this tomorrow by turning over everything. And if you continually talk about these kind of the bad apples, so to speak, I think there's a danger that prosecutors think, well, that's not me, that's not my office, that's not our culture. So yeah, you know, put the poster children and these hypothetical people, if you catch them, put them in jail, and we'll just keep doing business as usual instead of really focusing on the trickier issues like how do you make the system better? I mean, how do you get the information from the police that they might not be turning over to prosecutors? How do you get prosecutors to think more neutrally throughout the entire process so that they're screening for innocence, not just at the charging decision, but all the way through the case and looking at each piece of evidence in a new light? That stuff's much more trickier business than like, oh, when somebody does something super egregious, let's hammer them. That's fine to do that, but I think the harder work is these kinds of conversations, like how do you actually routinize the system? And we haven't even started talking about the timing of disclosure. We're talking about what do you disclose, let alone when do you disclose it. And I think there's a tendency for people to not even make those decisions until a case is right about to go to trial. You've got all kinds of people pleading guilty with very little exchanges of discovery.
That's another issue, I think, that Brady's actually virtually non-existent for plea bargaining. And I think that we all share some burden on that because we want to reduce our caseloads and get cases disposed of as quickly as possible when someone is willing. But sometimes people are willing based on the information that you have or lack of resources to actually mount a successful defense. So Brady in the plea bargaining stage is just something that doesn't even get looked at because you willfully pled.
To me, that's such an important issue because everybody agrees we shouldn't convict innocent people. But even aside from the fact that there are pressures on people to plead guilty, whether they are or aren't, shouldn't people make informed decisions whether to plead guilty or not? And these discovery rules, because of the timing, and maybe there's no cure because there's pressure to plead guilty at first arraignment, and nobody wants to sit in prison while the process is playing out. But shouldn't we recognize that one of the values here is enabling people to make informed decisions?
Absolutely.
And therefore, you need to accelerate disclosure.
Is there a timeliness component to the Morton Act?
There is, before any case is disposed of by plea, both parties have to certify in writing to the court that the act has been complied with and everything's been turned over, which has caused kind of the reverse problems. A lot of people that do want to plead guilty at first appearance or arraignment know, and it's led to issues. Can you waive the requirements of the Michael Morton Act? I believe there's still a difference of opinion between offices. I don't think it's settled yet. In most offices, I think the systems are catching up now. We've put in these systems since January 2014 to collect, amass, and move all this information. So we've gotten a lot more efficient. So it's not the issue it was the first year or so. But we've had very little case law on the Michael Morton Act thus far. But yeah, and for the regular trial, it's as soon as possible. And I can tell you, the prosecutors I'm around, we take that pretty seriously. It's hard to even, the first thing you do is start collecting and amassing this information, documenting it, and moving it to the other side.
Professor Burke, there's a story in one of your articles about a prosecutor friend that you brought to a conference who I think thought that he or she was going to be kind of beat up during the course of a couple of days. And then I think she leaves and says, oh, that wasn't so bad anyway. After all, I mean, following your previous comments, what can be done to kind of get prosecutors to buy in, right, on a host of these issues? The importance of the timeliness. Can we convince prosecutors that it shouldn't be so fault focused, and instead we should just be kind of working towards a more efficient and a complete solution, if you will, in terms of discovery.
Yeah, I think they are buying in, and I would say maybe over the last, I'm looking at Chris to see if she would agree with me, yeah, at least the last 10 years, I would say. The exoneration cases, there's just no question that those get a prosecutor's attention. That I respect Senator Greenleaf, I don't know if he's still here, but he was kind of being very self-deprecating, poking fun at his own naivete when he was like, we don't convict innocent people. You know, I think that used to be the conventional wisdom among prosecutors, and the exoneration cases present us with undeniable evidence that sometimes we do. And every one of those horrible cases is a teaching moment of, well, how did that happen? And I think prosecutors want to look at those just as much as anybody else and say, what can we do to not have that happen in our office so that we don't have to, realize that we make those kinds of mistakes. So the attention is there. I also would say about in the last 10 years, I have seen a shift in the rhetoric that is used to talk about prosecutorial decisions that might contribute to wrongful convictions, whereas traditionally they were always described as misconduct. You know, this was prosecutorial misconduct that led to that. People are being more careful to really talk about prosecutorial error or a Brady problem, because Brady problems can originate with the investigators where they don't turn over the stuff to the prosecutors. So even though it's a Brady violation, it's not really the prosecutor's wrongdoing that led to it. And really focusing on how to make systems better as opposed to necessarily concluding that every time a prosecutor's decision in hindsight contributed to wrongful conviction, that was necessarily an intentional act or even a reckless act. It's sort of how do we prevent these things ex ante? And that kind of focus, I think, has led prosecutors. That's why you've got a lot of prosecutors here. I think the tone here has been very cooperative. And I think the more that happens, the more prosecutors are willing to kind of step up. They're probably never going to have the same exact worldview as people who choose to devote their careers to public defense, but common ground, to use the title of your conference. I think the tone of reform movements have kind of gone in that direction.
Keir, would being more fault-focused, being less fault-focused, get more prosecutorial buy-in with respect to discovery?
I don't see how it would. And if you're less fault-focused, I don't think that there's any incentive to make sure you get it right. I know, to be honest with you, I mean, I don't know if they're buying in totally. I do know maybe on the more newsworthy cases, yes, we want to be more careful. But the majority of the cases that we see in our systems, I don't know if prosecutors are looking at their obligations so strictly and so severely. I don't believe that they think that it is a duty of theirs to go kind of making determinations on all these pieces of information that they have to turn it over. And I say that because we have uncovered so many, pieces of information that then we go back to the district attorney's office and put pressure on them. If you don't do something about this, we are going to now use our media. We are going to use, some of our other strategies to bring this up to light. Only then do they end up looking at it and say, okay, you know what? We should have turned over the fact that this officer was using this witness as a confidential informant. We should have turned over the fact that this officer provided this witness, loans with no interest, for the past 2 years. So I just don't think that they take it as seriously as they should in the average run-of-the-mill case, in my opinion, in my experience. And I think that there needs to be more fault on it, because when you have fault, then it's your obligation to talk to the police officer and say, hey, any of these witnesses in your case, informants, have you used them in the past? And it's not this willful blindness that they can hide behind if there is no fault.
I think that in every prosecutor's office and for every individual prosecutor, there are two very powerful norms that push you in completely opposite directions. One is the duty to do justice and wanting to do the right thing. And the other one is the adversary process and your desire to win. And for each of us who's been a prosecutor in every office at different times, one or more, you're somewhere on the spectrum, and everybody's in a different place on the spectrum. and you're never going to be able to get somebody to be completely do justice, I don't think. And that's why you need to have checklists and rules and things that are easily applied, be it open file or something else. But I think that at the end of the day, open file is not a panacea. And so the thing that I've always found troubling is you talk to witnesses. The prosecutor preps them, the police talk to them, et cetera, and they say lots of things. And some of them are internally contradictory over a period of time. One day the perpetrator is 5'6", and another day they're 6'5", or whatever. And the U.S. Attorney's manual says don't take notes in witness preparation. They don't treat it the same as they do the initial investigation. The police probably don't take verbatim notes. Nobody does. So how do those things ever get in your file? We think you're supposed to turn over prior inconsistent statements, and some of them are not only inconsistent but exculpatory, because the person who you arrested who's 6'5" is not 5'6". And no matter what you do, how do you ever get that stuff turned over if you don't have, say, taping of interviews, right? To me, the solutions can never in the end be on people's voluntary compliance with anything. You have to create systems that capture the information and make sure it gets turned over.
Okay, so the conversation about fault then, I think, segues nicely into immunity, which we have a couple minutes, and then we'll open it up for questions. So this might be a loaded question, but is absolute immunity a problem? If we're not confident with the criminal legislative solution that we talked about before, the justification for absolute immunity is we want prosecutors to bring tough cases. There's policy-driven arguments behind it. We don't want them to feel like there's somebody always overlooking their shoulder when trying to bring a case into court. Should absolute immunity be just changed to qualified, or is there a place for it?
Can I speak to that briefly? Just as a 25-year prosecutor, the line prosecutors in my offices and the offices that I have worked in, it is not at the forefront of our consciousness at all that we have immunity. I think maybe the first time I got sued, I wondered why it went away so quick, and someone explained to me after the fact this great immunity I have. A lot of prosecutors in my office, maybe if you put it on a multiple choice test question, yeah, I've got the best kind of immunity, but it's not something that really drives the day-to-day motivations of a prosecutor. I just, at least at my experience where I've been, it's kind of a non-starter or a non-issue to me.
For prison guards and police, they don't have absolute immunity, it's qualified, but they still get indemnified, so I don't think it makes that much of a difference. And you still have lawsuits potentially against municipalities. And so where we live, in the Bronx, they were sued successfully. I guess it settled for Brady violations. The DA, until he decided to leave and become a judge, was running essentially unopposed. It didn't make a difference to the district attorney. It didn't make a difference to the individual prosecutors. I see that as like criminal prosecution, not a solution. Because it only doesn't address the standard. It only addresses compliance. And I don't think most people are willfully non-compliant.
I was going to say the exact same thing as both of them just said, so you can skip me.
Keir, do you have any other thoughts?
Not on this subject. I just don't think that there should be immunity, and I think it should be more public, and it should be fault-based, where if it's prosecutorial misconduct, that should be made public. And so that would speak to a person's record of dealing with this in their office, because prosecutors, I don't know any of them who are not elected, but especially in this era where public trust in our system is declining in terms of whether or not you can get a fair trial, that would speak volumes to what this office has been deemed to have been producing in terms of fairness.
Why don't we open it up to questions from the audience?
I ask y'all just to speak a little more about the discovery plea problem? Because I think it's the volume-wise, that's where the action is, but also I'm really interested, particularly Bruce, in your thoughts, not just about the 3-8 piece and how that might affect prosecutorial obligations for pre-plea disclosure, notwithstanding Ruiz and that line of cases, but also on the 1214 ethics side. What's a defense lawyer's obligation when the client says, I want out today, and the lawyer either has no discovery or is looking at the discovery and says, well, you know, there may be something here. And I don't know, I know already there's not an answer, but I would really love to hear all of y'all's thoughts on this.
Well, I think that this is an area where some defense attorneys can be complicit in. But this goes to the larger discussions of reform. You know, first of all, if people are making decisions to get out of jail through a plea process, then, you know, that's a problem. If we talked about looking at the way we administer bail or cash bail or whatever it is, then we could kind of lessen those opportunities for people to be making those decisions just to gain freedom. If someone through a plea process can be out in the community, then they shouldn't have been in the first place. So I really believe that there are a lot of things that kind of coincide to reducing the likelihood that that happens. But I'm not proud of that process that sometimes we engage in, where we're looking at these, and some people pride themselves that we have rocket docket here. You know, we're looking at these opportunities of these systems that effectuate people making decisions based on their life that have high consequences, where me as a lawyer, we don't really have a full picture of what your opportunities are.
So, I mean, I always go back and forth on these questions. So to some degree, it strikes me that, you know, not that many people are going to do something different, plead or not plead, you know, if they got early discovery because the pressures are so great. But on the other hand, if you have ethical prosecutors and the prosecutors actually got the information and it was exculpatory, they might not, you know, they might dismiss the charges. I mean, it's not just the defense that doesn't have the stuff, it's usually the prosecutor. I don't think a defense lawyer can say, Your Honor, I won't go forward with the guilty plea. I won't advise my client because I don't have enough information in order to give informed advice to my client. I think that is true. You may not have enough information to give informed advice, and yet there's an unfairness in saying my client has to sit in jail because I'm waiting a few more weeks to get discovery. So I don't know what the defense lawyer does about it. I mean, again, it gets back to what kind of systems you put in place in order to get information to people earlier in time.
The only thing I'll add to that, under the Michael Morton Act, it's a continuing obligation post-conviction. So we have had situations where we've had exculpatory evidence come up post-plea and had to go back and undo it. So that's a frequent scenario, a common scenario in Texas. Frank.
I'd like to thank the panel, first of all, for coming at this with such a collaborative manner, and all of you represent the best of what your professions have in the way of ethics, integrity, and wanting to do the right thing, so thank you. And we're here to discuss common ground, but there's also that 1% of every profession, mine and yours, that are tempted to cheat. And in the justice system, it's those people that have caused some of the most egregious injustices that have led to thousands of years being spent in prison by innocent people. So, and I'm sure that each one of you abhors behavior like that on the part of your compatriots who do fall into that temptation to cheat, and would like to see those people held accountable because it tars your entire professions, my entire profession, when someone is a bad actor. Now, in the prosecutor area, Bill, I wish I had run into you in the Southern District of New York, but unfortunately, I ran into some more ambitious people who were making about $60,000 a year working very hard for the federal government, and no one knew them. But as soon as they brought some high-profile cases and got their names in the Wall Street Journal, they got hired by Sullivan and Cromwell and other fine defense firms making 50 times as much money. And when their bad work was uncovered, they were never punished, and they rarely do get punished. A study that we did in the Northern California Innocence Project showed that 700 cases of prosecutorial misconduct, as determined by appellate panels, in only 6 of those 700 cases was there any sort of public discipline, let alone prosecution, which is what we were talking about earlier today. So I would ask, if chief executives or bankers were never prosecuted for their crimes of fraud and could never be sued by their victims, do you think that we would have more fraud or less fraud? And that relates to the 1% of the bad actors. And so why should prosecutors be the only profession in our country who can intentionally, egregiously break the law to deprive people of freedom and never be held accountable? And shouldn't qualified immunity be the right standard? Because if we as business people are held accountable for our intentions, why shouldn't the folks whose job it is to uphold the law be held to that same standard?
I feel like the question was aimed at me, so I can't disagree with it, especially the way you framed it. I can tell you this, we've talked a lot about the Michael Morton case. The prosecutor that handled that case did get convicted and did see jail time. So I can't disagree with it. I can tell you a couple different things if this gives you any hope. I think there's hope in the future. When I came up in Dallas, we were judged on our trial skills, we were judged on our one-loss rate. Now, when I'm just up the road in Collin County, we don't collect one-loss rates, okay? We do all this training to get away from it, and sometimes I feel like it's lost on the new generation. The new generation has come up in the age of exonerations, and they look at things completely differently than I looked at them when I started, completely differently than I was trained to look. So I do think there's hope in the future. I can't disagree with what you said.
So I might. I mean, it's very hard to take issue with a question that begins praising the panel.
We love you now.
Right, exactly. So to me, if you're talking about I don't know that the number is 1%, but if assuming it's 1% bad actors, they can be prosecuted in theory, although they never are. They can be disciplined, although they rarely are. To me, the reason why I would get rid of absolute immunity is not because it's another regulatory device, because I do think these people are going to be indemnified, and so they're probably not going to be worrying about it, but because I think people should be compensated for the harm done to them. So I think of Koenig against Thompson as a horrible case. I think if there was one more vote that went the other way, it would have been much better from my point of view, but not so much as a disciplinary regulatory matter, just because of the unfairness of that. But the other thing that we haven't really talked about, because we are so common ground oriented, is it 1%? Is it 5%? Is it 20%? And so Judge Kaczynski talked about an epidemic of Brady violations. Yeah. I don't believe he proved that there was an epidemic based on citing 20-odd cases that took place over 30 years, many of which might have been Brady violations because of the prosecutors, because of the police, not the prosecutors, some of which may have been inadvertent or mistakes, not intentional. I don't know that, honestly, that the California study parsed the cases closely enough to know that they were all cases of intentional misconduct by prosecutors. And even at that, I'm not sure what you would say about the number as compared with the thousands and tens of thousands of prosecutions brought each year in California. So I just, maybe I'm raising an issue that we never should have raised. But do you think it's 1%? Do you think it's 0.5%, 10%?
That's really hard to say. Honestly, that's hard to say. I wouldn't know where to begin to. To me, I feel like it's much more than 1%, but I wouldn't want to put that out there as an expert opinion.
Sandy.
I have a doctrinal question relating to, I've read some blog posts recently relating to 2 cases that are on the Supreme Court's current docket. They're consolidated, Turner and Overton. This isn't my area of deepest expertise, but I've read arguments that there's still room on the basis of the Supreme Court's Brady jurisprudence, to argue that the Brady standard is, in fact, as originally intended, the standard for when a due process violation requires setting aside a conviction rather than the disclosure standard, and that these two cases, Overton and Turner, present an opportunity for the court to make that clear. I'm just curious, do you all think that that is accurate? And what's the prognosis for the court taking that path? And if it did, would it do anything? Because if it's not a standard for a violation that requires setting aside of a conviction, if there's no remedy, does a right without a remedy accomplish anything for the larger?
This is what two law professors talk about on a train while other people are talking about fun things. They talk about this case and blog posts and whether we agree with it or not. So I think we'll both take credit for this idea. Some of you may remember, it's called Dick Gershman, right? The Supreme Court case where they said Miranda is a real thing. We still have Miranda. It's reinforced. Yay, Miranda. They took 20 years of cases where the Supreme Court had said Miranda's not a real constitutional right. It's a prophylactic rule, court made for purposes of protecting the real Fifth Amendment privilege. 20 years of those cases. And then when somebody came along and said, okay, so if Miranda's not a real constitutional right, Congress can get rid of it by statute, and here's this old statute that did exactly that. And Rehnquist writes this opinion saying, no, Congress can't get rid of Miranda. And 20 years when we said it's not a real constitutional right, we didn't really mean that. I think it's possible that these cases will go that direction and they'll reframe Brady. But I don't see personally a reading of the Supreme Court cases right now other than that the standard is that you only have to disclose material exculpatory evidence. I don't think that should be the standard, but it seems to be the way they've described it. Could they find a way to mine their own language and say we were only using that as a retroactive standard for determining whether to reverse a conviction? Sure, if the votes are there. I actually think that that should be the standard. It should be a big standard of disclosure, and then you can use the materiality standard as the reversal standard, right? So who knows?
There are a couple decisions. Paul Friedman in D.C. wrote a decision, and he said, and there are a couple others around the country, California, maybe Nevada, and he said that the judges used to call themselves the Brady bunch, the ones who thought that Brady, the materiality was just an after-the-fact standard. But, and there was at least one oral argument where I think it was a Justice Breyer or Kennedy seemed to think it was.
He was very confused. Why are you saying that that's the standard?
Right. So you never know.
Oral argument. I think that they can absolutely make that. They can actually make that statement. I think it's time. It's time to stop looking at turning a blind eye and providing a minimalist approach and a minimalist type of guidance to what people should do to effectuate fair justice. I don't know what we would need to figure out how many cases. I think Brady violations are pervasive in our system, but that's just my thought. I don't know specifically. I don't know if anyone's ever done any studies on it. But quite frankly, I think the way that the court has left it open is really what drives lack of incentive.
I'm just interested in the thoughts of the panel, assuming that this would be of any use. But what do you think the prospects are for getting some well-done empirical research on this very question of how widespread this problem is? Because it seems like one of the problems is we don't even have a baseline for that conversation. Because there's no data that I think is really very empirically defensible at this point.
So I might jump in just quickly. That's a future project of the Quattrone Center. So
when is that starting?
Right? Will that be public?
We're hoping to make some inroads there by basically creating a taxonomy of Brady violations, hopefully in either one large jurisdiction or in multiple jurisdictions to get an idea of the nature of the different types of Brady violations. And then, frankly, to not only create that taxonomy, but to have conversations with prosecutors about it and to kind of get their perspectives on which of those they consider to be serious and which of those they kind of consider to not be so serious. And that goes to the buy-in we're talking about in terms of prosecutors being part of the conversation as well. And then we hope to link that work to the discussions about fault and liability and absolute immunity doctrine. So it's
And have you been able to get all the stakeholders to agree to share files and data?
This project's in its beginning phases.
Okay.
So we're
Okay,
just
thank you.
beginning it.
Just a point of disclosure, my name's George Schatzbarger. I served in the Philadelphia DA's office for 28 years and retired in 2007. A lot of the discussion here is academic. It presumes that there's a single prosecutor with one file at his desk, and that prosecutor is carefully reviewing every shred of evidence and is making very highly nuanced decisions about what to turn over or not, and that is so far from the reality I feel compelled to speak about it. When I retired in 2007, my personal case inventory, the major trials program, was over 240 cases. Almost every one of those files involved a mandatory minimum jail sentence. Shootings, stabbings, armed holdups, major weight drug cases, you name it. And if we can just do this math, every one of those cases was docketed within 6 months of its arraignment. So what was my caseload like? Bill at least talked about the lying DAs in his office, incredible pressures. And for anyone to think that that DA is sitting there at that desk with only one file on it, looking over every shred of paper, is just unrealistic, and therefore sanctions against those DAs who might make mistakes or in the press of business might miss something, I think should be tailored to that reality. And I just offer that in general. But I also say this, that every single DA in my unit, under similar case pressures, when receiving a request from a defense attorney who is representing the client zealously for a specific piece of information or an avenue of investigation, would do whatever he or she could to comply with that request. So it's not just this one-way street where it's all on the DA to turn over, all on the DA to turn over. In the press of business, there has to be some defense effort, zealously advocating for the client to, in a sense, become the squeaky wheel that causes that particular issue to get oiled in an otherwise system, in a system that's otherwise too busy. So I offer that for your discussion, not to excuse flagrant violations of discovery rules or Brady or anything else, but every case has to be evaluated from the environment out of which it arose, as opposed to an academic environment which is placing, I think, false standards on people who are working exceedingly hard to do the right thing on every case, but time does not permit them to do the right thing on every case. We had that discussion earlier with the defenders. Too many cases, too little time. Things get missed. I think that any system of sanctions has to take that into account.
So speaking for myself, since academic was the word, I'm sorry if I misspoke. My criticism of Brady is that the court seems to be picturing one prosecutor on an ad hoc basis deciding whether to disclose something and looking at each piece of paper and imagining the trial. And that's why I think, I personally think discovery needs to be extremely routinized, meaning that when I was at the DA's office in Portland, I really didn't make that many discovery calls because right after arraignment, there were people whose names I didn't even know who copied the police reports and left them at a desk for defense attorneys to pick up, and I never had anything to do with it. The only thing I really had to think about was stuff that came in after the fact, what was discoverable and what wasn't, should I turn it over or not? So I guess I wouldn't disagree with you on that. It's silly to think that prosecutors are going to reinvent the wheel with every single case. What should I disclose or what shouldn't I?
But I think that's why we talked about a list of information that should be, a checklist that should be turned over. And I agree with you, defense attorneys do have some responsibility. However, we only know what we know. We don't know what officer is currently under suspension or on suspension. We don't know what officer has been tagged for IAD for certain things that are impeachment material. And so when prosecutors don't ask those questions, or they don't even, they turn a blind eye on whether or not certain officers have some character information or character issues, I think, to me, that is an egregious conduct, and it could be something that is really, really important for the administration of justice in this particular case. I don't think for one moment, think that it is a prosecutor that's going to look at every case and say, what is every piece of information that I can get to the defense counsel? I think that's not practical, but I think there are some things that are glaring that are still not happening.
Why don't we thank all of our panelists